evening. My name is Walter Quinteros. I have the pleasure of moderating this awesome panel here tonight. Okay, so I want to thank them for taking time out of their busy schedules to be here with us and share some of their knowledge and experience with us here tonight. Here we have Mr. Stuart Chang, who's an assistant professor of law at Whittier Law School. He's also an assistant professor of English by courtesy at Whittier College. He joined Whittier Law School faculty in 2011 after 10 years of practicing as a staff attorney at the Asian Pacific American Legal Center. Professor Chang's scholarship applies to critical race studies approaches to immigration, family, and constitutional law. To his left, we have Salvador Sarmiento, who works at the National Day Labor Organizing Network. His position is a Legislative Affairs Director. To his left, we have Amanda Trefethen. She is an attorney and lecturer at the Department of Philosophy at the Cal State University of Long Beach. Before teaching at Cal State Long Beach, she was a tort attorney, primarily specializing in consumer protection and large-scale product liability cases. With degrees in both law and philosophy, she now teaches in the area of philosophy of law, global justice, philosophy of race, and feminist theory. So let's go. So I guess we can start with Professor Chang.
Okay.
If you want to go ahead and give a quick introduction.
Okay. Well, thank you for having me. And what I'm going to do is just give you a little bit of a, because what we're talking about, I think, for this whole panel is the effect of the election on immigration policy. Is that right? Okay. So let me just give you a quick rundown of about how immigration law is structured through the separation of powers, which I think will give us an understanding of why it's important that who we elect is going to have a good deal of say of what's going to happen with immigration policy coming forward. Okay, so this is no good. Okay, so just an overview of American immigration law, that we have three types of issues whenever we look at immigration law. We have eligibility, so who is eligible to become an immigrant. Admissibility, so even if you're eligible, and we'll talk a little bit about eligibility in a second, even if you're eligible, that does not mean that the United States will actually let you in. You also have to be admissible. If you've done certain things like committed certain crimes, you could be inadmissible and the United States could still keep you out. The way I tell my students is it's like the hand, that before you get in, you encounter Customs and Border Patrol, and they at that time can determine whether you're admissible or not. So they can give you the hand, basically, and say, go back. And then there is also removability. So after you've made it into the borders, the United States can, until you become a citizen, you can still be kicked out of the country. So say, for instance, if you commit certain crimes, you can be kicked out. But after you've been admitted, you are entitled to due process protections. Okay. Now, the powers of the legislative branch determine who is eligible, who is admissible, and who is removable. So this is the power that is in the Constitution known as plenary power, which is the power to regulate and control your borders. That your sovereignty as a nation allows you to control your borders, determine who gets in, who stays out. And so the courts have found that Congress has the last say in terms of creating the laws that determine who they will allow to come in and who they can also kick out. The executive branch, though, is the administrator of the law. So it administers admission and removal of immigrants and non-immigrants. So the difference between immigrants and non-immigrants are immigrants are those who are eligible to become permanent residents, who can get a green card. Non-immigrants are those that are here just temporarily, so just here for temporary stays. The judiciary is generally uninvolved with immigration law and immigration policy. It does review executive agency decisions. However, it is highly deferential to the legislature and is very deferential to the executive branches also. As a matter of plenary power, it says that if you're an immigrant before you're a citizen, United States can discriminate any way they want in keeping folks out. When I used to teach Asian American Studies here at Cal State Long Beach, I would talk to folks about the 1882 Chinese Exclusion Act. Congress had the absolute power to say, well, if you are Chinese, we can exclude you. If you are, and then later on, if you are Asian or come from certain countries, in 1917 they created a Asiatic barred zone that said that if you are of certain races, we have the power to exclude you. And this has not been questioned. It is absolute power, absolute plenary power. Also, you have deference to the executive agencies, so that if the ways in which the administrative agency decides to apply the laws, judiciary is very, very deferential to. The questions they ask is, has Congress spoken on the issue? And if Congress has not spoken on the issue, is the administrative agency interpretation permissible? So it is highly deferential to the decisions of the executive branch. So this gets us to the executive offices that are involved. So we have the Department of Homeland Security that used to be Immigration and Naturalization Services, but after 9/11 was reorganized under Department of Homeland Security. And the three primary branches that deal with immigration are Citizenship and Immigration Services, Customs and Border Patrol, and Immigrations and Customs Enforcement. Citizenship and Immigration Services takes in applications of those who are eligible to determine whether or not they're eligible to come to the United States. Immigrations Customs Enforcement is the prosecutorial branch. If you've done something that makes you removable, those are the folks that will initiate removal procedures. And Customs and Border Protection are the folks, if you come through the airport, those are the folks that check to see whether or not you have the documents to enter. Any appeal of the Department of Homeland Security is handled under the DOJ through the Executive Office of Immigration Review. So it is an administrative law judge, not a judiciary judge, and then the review of that is the Board of Immigration Appeals. And it's not until you get past the Board of Immigration Appeals that you finally get to the circuit courts for reviews of the administrative agency decisions. And then the Department of State and the consular offices are responsible for giving entry visas to folks that are abroad. And I'm going to skip this since we're short on time. And this is just a chart of all the executive offices that are involved with immigration. Okay, so we saw that Congress is responsible for determining the rules for who gets in and who gets kicked out, and the executive office is responsible for administering it, and also administering removability. And this would get us to some of the executive actions of President Obama. So there are approximately 11 million undocumented immigrants in the United States. Now, we have this myth that many of them are across the border. Yes, there are those who do what we call EWI, entry without inspection, which is they cross the border and they are not inspected by an officer, and they then are never really admitted. However, a good number of those who are undocumented immigrants are actually overstays on their visas, who they at one point in time were admitted and inspected, but since that time their documents have expired and they've overstayed. Now, this problem of 11 million undocumented immigrants who are still contributing to society, President Obama tried to deal with this first with deferred action for childhood arrivals. So those, it was an executive action, and it is an exercise of prosecutorial discretion, which means that, remember how I told you that the executive office, ICE, is responsible for administering removal. Well, the deferred action for childhood arrivals, DACA, is essentially says that, well, okay, there are going to be a certain classification of individuals who we want to deprioritize for removal. That means that even though we're aware that they're here, we're not going to put them in removal proceedings. That they're not really a danger, they're not really a public safety danger, so we don't want to necessarily deport them. On top of it, we want to give them eligibility for work authorization. So we are going to give them what is called deferred action status, which is not a grant of any sort of technical legal status, but it's just an exercise of prosecutorial discretion that says, well, we're not going to remove you. Now, Along with this, so DACA 1 actually is currently in effect. Since then, President Obama also tried to initiate what is called deferred actions for parents of Americans. So for the parents of children who came, entered without inspection or overstayed their visas. But DAPA and an extension of DACA, which we call DACA 2, was blocked. And let me just by the state of Texas. So the Obama administration had tried to implement and create a DAPA program, and it would have granted deferred action status to undocumented immigrants who are parents of United States citizens or legal permanent residents. But it was challenged by 26 states, and a preliminary injunction was initiated that prevented that from going into effect. And this injunction was sustained by the Fifth Circuit and by a 4-4 tie, also then sustained by the Supreme Court, because Justice Scalia had not yet been replaced. And they're still awaiting the decision on the substantive merits of that case. Just to give you a quick overview of DACA, so why is it that we want to deprioritize them? Well, you have to be under 31 years of age as of June 15, 2012, entered the U.S. before the age of 16, have had continuous residence in the United States since June of 2007, and have been physically present in the United States on June 15, 2012, and at the time of your application. You have to have had no lawful status as of June 15th of 2012, and you either have to be currently in school or have completed high school GED or have had an honorable discharge from the military, and on top of it, no felonies, no significant misdemeanors, which has special legal meanings, and you're not a threat to national security. So again, these are the reasons why you deprioritize these folks for removal. Now, the effect of the presidential election on this is that, well, it is an executive action, right? This does not involve the legislature at all. So that the survival of DAPA and even the ability of DAPA to proceed at these court levels largely depends on who is going to be the executive and whether or not they are going to exercise this type of prosecutorial discretion. Okay, I know that was a lot of information, but thank you for your time, and I'm sure we'll have questions and discussion afterwards.
Next, Salvador, do you want to?
Sure. Hi, everybody. Can you hear me okay in the back? Cool. I think that's a very good, kind of like overview of what we're dealing with when we're talking about immigration law. Immigration law is massive. It's often incoherent in the sense that it's like layers upon layers of laws that were passed in very similar context that we're dealing with today in the United States, where there's like, can you imagine what bill would pass out of Congress in 2016, if there had been a bill in 2016 with this Congress, you cannot argue that this is not a dysfunctional Congress. If a Congress like this passes a law, what that law would look like, right? And that's kind of the history of immigration law. It's always kind of the product of this insane negotiation where a bunch of people get thrown under the bus, you get a couple good things, a lot of bad things, and imagine that over a 200-year history, right? And that's where we get to where we are today, right? So it's like, I was chatting right now, it's Adam. It's just like, there's so much in it, and how do you even make sense of it, right? So I don't know how you make sense of it, but I do know that what the impact has been for folks, for immigrant folks, and so for some folks that aren't even immigrants. And that's kind of where I approach immigration law, immigration policy. I'll start off from there because that's kind of like where I'm coming from a little bit. I think everybody here is anybody here familiar with the case of Jose Alvarez? Okay. So Jose Alvarez is a father who had been working here in Long Beach, a gardener and many other jobs, construction. And about almost six months ago or so, his son, Victor, works at Krispy Kreme. And he was getting picked up by, well, he was going to go pick up his son. It was late in the evening. And he was stopped by Cal State Long Beach campus police, a broken headlight. So he gets stopped. Jose, the father, has what's called an ICE hold, basically a request from ICE, from the immigration police, hold him until we can come pick him up. So they hold him. Not only does the campus police officer hold him, he brings him on campus so that and holds him until the ICE agent comes, picks him up. Jose gets deported within 7 hours, right? It turns out Jose, the reason he had an ICE hold is because of a 21-year-old prior conviction, a nonviolent drug offense from 21 years ago. And he had gotten the conviction and he was deported. He came back to be with his kids. 20 years later, he has 6 U.S. citizen kids. His oldest son is a veteran of the U.S. Marines, and he was deported like this, right? And so he's living in Tijuana. And about a week ago, he was actually in a car accident, him and his wife, because his wife goes and visits him. His wife's in the hospital in San Diego. He's in Tijuana. His 14-year-old kid can't walk right now, is in a wheelchair. It's just the impact, and Jose's like dealing with his own injuries in Tijuana. He doesn't have insurance. And his kids are, one left school. Victor, who he was picking up, ended up leaving school to be able to help the family with finances and whatnot. So that's a very real, reflection of what the immigration system looks like. Whether it's broken, whether it's working, whatever the heck it is, it's doing what happened to Jose's family over and over and over. And the fact is, the machinery still exists for that to keep happening over and over and over. And so basically, I'll kind of just throw out a couple ideas about how we approach immigration, or how we don't approach immigration. Then what we really like to do is have a good conversation and kind of see where you all are at. What are your specific interests? Like, why are you here? Right? So, civics lesson. How many branches of government? Right? What's the one with the balance? What do we call that one? The courts, right? So in terms of immigration, the courts are incredibly deferential to the executive branch on immigration. But there are moments when they step in, right? And the courts can easily be used in a political way, right? Most recently, US v. Texas is the case where they blocked the implementation of DACA for parents, right? So there's the court. But also, they also stepped in certain cases, what they did here in Cal State Long Beach, where ICE asked the local police, hold him for a minute. Hold him actually for 48 hours. Who knows who's been to law school or is interested in law? How, for a police officer, for any law enforcement officer, for any agent of the state to hold you, to detain you, what do they need? A warrant showing probable cause, right? There's a couple exceptions, but they're really specific and they're supposed to be really narrow, right? But an agent of the state, a law enforcement, a cop, needs a judicial warrant, judicial meaning signed by a judge, to hold you or to detain you, right? An ICE hold, ICE issues thousands of holds of requests for people to be detained with absolutely no judicial warrant and regularly without any showing of probable cause, right? And so federal courts about a dozen times have stepped in and says, that's illegal. So has ICE stopped doing it? No, ICE just keeps issuing thousands and thousands of ICE hold requests across the country. The most recent federal court decision was out of Illinois, in the federal court based in Illinois, like 2 weeks ago, right? And it's pretty darn clear, like, if anybody asks, like, how long can a cop or an ICE agent hold you? Or actually a cop, how long can the officer hold you without probable cause? How long? Is it 5 minutes? I'm sorry? 72 hours? 48 hours? ICE says 48 hours. You can hold somebody for 48 hours. Not 1 minute. Is the correct constitutional answer is not 1 minute. You can't hold somebody if there's not like one of the exigent circumstances or a judicial warrant showing probable cause. So there are moments when the judiciary will step in, when the ICE is a rogue agency and does all sorts of crazy things, right? What's the other? That's the executive branch. I can't draw. What's the most recent things we can learn about the executive branch in terms of immigration? Magic number, 3 million. Record-breaking deportations in the last 8 years. We'll reach 3 million, unfortunately, sadly, probably by the end of the year. We're up like 2.7 right now. 3 million deportations. The federal government cannot have reached 3 million deportations by itself. The only the way they reach 3 million is by a series of ICE programs called ICE Access. Right? And we'll go into a little bit more of into the weeds of what the heck these ICE Access programs are. Secure Communities, the Criminal Alien Removal Initiative, CAP, the Criminal Alien Program, the 287Gs. You all heard about Sheriff Joe Arpaio that literally was just criminally charged yesterday. Right? Orange County is literally the last 287G jurisdiction in California. These things are incredibly backwards, where they literally deputize local law enforcement to act like deportation officers, right? So there's all these programs under the banner of ICE Access, right? That's how they reach 3 million deportations, by literally using local police and sheriffs to reach that number. What are we missing here? Third branch of government? There's like a little man here with a Liberty cap. Congress. Congress is incredibly important because for the last 20 years, how do you resolve the broken immigration system? What have we been told? How do you resolve all of this? 11 million undocumented people in the U.S. How do we resolve it? There's a magic phrase that people say. What kind of immigration reform? Comprehensive immigration reform. C-I-R. Comprehensive immigration reform. It's engraved in our brains, right? For 20 years, we've been told that the only way to do anything about immigration, and we took, for example, because these are very real world consequences of what the status of the law and policy are. Between 2013 and 2014, $36 million went to convincing 30 Republicans that we needed comprehensive immigration reform. We needed 30 Republicans to get out of the House in 2013, 2014. How many Republicans of those 30 did we convince? And these were the moderates. How many did we convince? One. One of the California, I think Valadeo in California. He said, okay, for about a week, and then he pulled out. Right? So we haven't figured this out. And not only that, is that we can't only rely on Congress to start talking about this. Hence, over the last bunch of years, a couple, specifically mostly very local organizations that don't get any money from Washington, D.C., started saying, what the heck can the executive branch do to address some of these issues? Because the Congress isn't going to, come 2017, what has the Democratic candidate for president, what has she promised in the first 100 days? A bill in Congress. Right? Do you think this Congress is going to change a whole lot in 2017? I don't know. I don't know what the answer is. I'm assuming you all do, though. I wouldn't, if there's going to be a bill come next year, I don't think it's going to be a good one. But the executive branch there's still a broad menu of what the executive can do in terms of, for example, all of these ICE Access programs. When Sheriff Arpaio in Maricopa County was openly saying, I racially profile, I'm going to keep racially profiling. At that moment, DHS, under the executive branch, was still playing ball with Sheriff Arpaio for years. After everybody knew that Sheriff Arpaio was violating civil rights left and right, DHS did nothing and just kept deporting the people that were being racially profiled and illegally stopped by Sheriff Arpaio, right? And so eventually it took years and a whole international outcry for DHS to cancel the 287G program in Maricopa County, Arizona. But it's such a good example because one of the reasons that SB 1070, remember the Show Me Your Papers law in Arizona, which was everybody knew was was like a scapegoating against immigrants and whatnot. The reason it was so hard to litigate is because under the executive policies, SB 1070 wasn't that far away from what DHS actual immigration, not just the law, what immigration policy was. Yeah? So the last thing I'll say is that right now, going into 2017, there's two big excuses that are being used to advance deportations. And people might say, well, deportations have gone down a little bit in the last 6 months, last year or so. Actually, probably the last year, deportations have gone down. We were averaging like 400,000 a year. Right now, we're over 200,000 or so. They basically pulled their foot off the gas the last year of the current administration. The machinery is all still intact and operational. Secure communities, all the ICE access programs that for another day we can go into them. But all the machinery still exists for anybody, for whatever political reason, to press on the gas. And so I guess the only thing I would say is that right now there's two big excuses that are being used to target folks. What do they say? Why are they deporting the recent arrivals? The refugees from Central America. Deterrence. First big excuse to target recent arrivals, deterrence. Is it slowing down the flow of refugees fleeing violence in Central? Of course not, right? But that's the rhetoric being used around deterrence. The second big excuse to target immigrants today, has anybody heard of felons, not families? That is the banner, the White House's new banner to justify all of the ICE access programs, specifically a big one right now called PEP. Felons, not families. You're either a felon or your family. You can't be both. Jose Alvarez is a felon. Hence, he is no longer a father. Hence, he is a number, and we could deport him without a second thought, right? So right now, in the 90s, under the drug war, and Bill Clinton signed this terrible anti-immigrant law called IRA in 96, it was very hostile. Basically, it was like, how do we punish these lawbreakers more, right? The rhetoric back then has basically carried us into 2016, and the new good immigrant versus bad immigrant, the best way to the new way of describing the good immigrant versus the bad immigrant is felons, not families. And that's the signature immigration banner right now. And so all of that, we can have a conversation about it, but that's kind of what we're up against right now. We're talking a lot about rehabilitation and second chances and and mass incarceration and reforming the messed up criminal justice system and and racism in America. A lot of what's been advanced in racial justice and criminal justice reform does not apply in immigration. And so if you're an immigrant, if you're not even just an undocumented immigrant, if you're a non-citizen, if you're a legal permanent resident, and you have a 10-year-old, a 20-year-old conviction, you're out. And there's no excuses. You have ceased to be a human and you become a felon, right? So that's kind of the challenge. We need to start talking about those kind of things. Thanks.
So before we move on to the other speaker, I want to introduce one more speaker. And that is Professor Annie Lai. She is a professor of law at the University of California, Irvine. She's the co-director of the Immigrants' Rights Clinic. Professor Lai teaches the practices in the area of civil and immigration law. She believes that the law has a unique role to play in advancing individual and collective demands for dignity and equality by immigrants, communities of color, and youth. So, welcome.
Thank you.
And next we'll hear from Professor Trefethen.
Oh, well, building off what Salvador said, although I am a lawyer, but I'm not an immigration lawyer. I teach philosophy here, and so in terms of philosophy, I generally think about concepts and the meaning of concepts. And this election, this campaign cycle certainly challenges our notion of the meaning of some concepts. One of the concepts that I thought would have more play in this election, which has kind of died down a little bit, is the notion of so-called sanctuary cities. Donald Trump has said actually on his website, it says specifically only one statement. End sanctuary cities, that's his policy. And in his speeches, he's talked about why he wants to end sanctuary cities, and he says that they harbor dangerous illegal immigrants who commit crimes against Americans and who are responsible for so many needless deaths. And usually in that speech, he's referring to a case in San Francisco having to do with Kate Steinle. Obviously a tragic case. San Francisco, he considers San Francisco to be a sanctuary city. We'll talk about that concept in a minute. But in that particular case, I remember the details. What is his name? Francisco Sanchez, essentially a homeless man in San Francisco. He had been deported 5 times. He had been convicted for 7 different felonies, some of them felony reentry cases, but a lot of them drug-related cases. Not a great guy, clearly a bad, sort of not totally together guy. He's homeless and living down by the Embarcadero in San Francisco, and according to his account, he finds a gun wrapped in a t-shirt under a bench. He's maybe high on a couple of different drugs, including some painkillers and sleeping pills, and he decides to take some shots at the seals at the Embarcadero and misses, I guess. Anyway, shoots Kate Steinle in the back, and she dies pretty soon after that. Clearly a terrible story, and it's also a story that can maybe make some hay in terms of elections, because the charge there was that San Francisco failed to turn him over to ICE when he had an ICE hold. He had a detainer. He had been in prison in San Bernardino. They released him. He didn't have any active warrants at the time. And so there was some either miscommunication, I don't think, the case hasn't gone to trial yet, so it's not entirely clear what's happened. But the thinking there is that San Francisco is what's called a sanctuary city, and by the way, so is Los Angeles, and so are about 12 other cities, including about 300 counties across the United States that technically qualify for what we call sanctuary. But we should be really careful about that word, because there's not any sanctuary anywhere in the United States from ICE or from immigration enforcement. There's no place that you can go that's safe from that type of enforcement. The question is whether or not, and to what extent, different cities are going to cooperate and make it their project to enforce immigration policies. And to what extent they ought to or should take that as their project and direct certain funds, municipal funds, toward that end. So we call them sanctuary cities, but it's clearly a misnomer, right? Because it's not the case that there are places that immigrants can go to be harbored or sheltered from immigration enforcement. The question, I guess maybe the reason we call them is sanctuary cities, I'm not really sure. It could be a holdover from the sanctuary movement of the 90s. I don't know if you're familiar with that, but during the late 80s and 90s, which I guess led to the IRA legislation in the mid-90s, there was a movement, mostly across the Southwest, that was put together by several different church denominations. Because there were rampant civil wars across much of Central America, there were a lot of refugees making their way to the United States. And we still had some pretty draconian policies and not really doing a good job of hearing properly refugee and asylum cases at the time. And so people were making their way into the United States, and then they were being deported back to their countries where they faced certain peril. And so the churches across the Southwest, and actually making their way all the way up to like Chicago, sort of created what's been called an underground railroad of sorts for providing safe harbor, an actual kind of sanctuary for people making their way into the country. And there were many legal cases that fell out from that. I think the defense of the churches against the federal government at the time, they waged, they used some international law arguments about refugee and asylum law, but they also used First Amendment arguments, freedom of religion arguments that dated back to like Deuteronomy and this idea that there could actually be cities of refuge. There could be places where people could be safe from that type of enforcement, legal enforcement. But that's not the case when we hear on the campaign trail talk about sanctuary cities. It's a completely different sort of question. And so it's pretty important to keep that concept separate and not think that sanctuary means actual sanctuary. What's going on in sanctuary cities, now I have to do like air quotes every time I do, now I'll have to do this repeatedly. But what's going on in so-called sanctuary cities is this question about how far cities have to go to participate or cooperate with ICE. And in Los Angeles, since 1979, we've had a policy that says that police officers cannot stop you, specifically to ask you about your immigration status, that's forbidden, and that they're not going to direct municipal funds toward that type of enforcement action. And they're not really going to investigate very much about your immigration status if they stop you. And that's been the policy here for a really long time. And the question, I suppose, is every city, every municipality, every county has to make some kind of decision about that question. And really, it's better to think about it in terms of a spectrum, perhaps. On the one hand, you have Sheriff Arpaio, who takes it as his personal mission to engage with people, to racially profile them, to stop them, and that's not his job. And the court has specifically said, that's not your job. You need to stop doing that. And what happened yesterday, today, is a criminal contempt charge because he won't stop doing it, stopping people. Just driving and stopping them because the police officer takes a look and questions whether or not their status is appropriate. So that's clearly been said, that's one end of the spectrum where you say, well, should cities and municipalities and counties be in that business? We certainly wouldn't want that to be the case. And on the other hand, we don't have a far end of the spectrum where there is actual sanctuary, right? But there are cities who want to state a policy specifically and let their communities know that they don't take it as their job to do that type of work. And why would they want to do that? Why do you think they would want to? Why shouldn't states and municipalities make it their project to stop people and ask them about their immigration status?
It's expensive and it's inhumane.
Yeah, and also they have a specific job, right? Community policing requires a certain amount of trust. It requires a certain amount of communication with the members of your community. You want them to be able to call the police. You want them to be able to seek out police contact. You want victims to be able to call the police. If you have a situation where any police officer can ask you what your immigration status is, what kind of a deterrence is that going to be for good policing, right? For being able to do the job that local communities need to be able to do. So that's the reason for these policies. And somewhere on the spectrum, at the far end of the spectrum, are cities who specifically stated that policy. That's what's called sanctuary, right? The sanctuary comes from you can dial 911, and you don't have to worry that that sort of contact is going to put you in further danger of being deported within 7 hours, right? You don't want that to be the case. So that's the state of sanctuary, right? That's the idea. And that's, I suppose, what Hillary Clinton has said. She doesn't take a position on sanctuary cities because I think she thinks that that's a mythological term. But she does encourage community policing. She does encourage some notion of subsidiarity, allowing different local communities to make these types of decisions for themselves. And so that's the policy I believe that she shares. But you should just, so my main point is the far end of that spectrum is not safety or harbor or sanctuary. It's that there are some communities that have declared themselves to be the type of place where community policing is really about taking care of the community. And it's the federal government's job to do the other types of enforcement. And the type of cooperation that they're going to engage in is friendly, maybe, ideally, at that end of the spectrum. But at the other end, where the local communities take it as their project, as their job to do that federal enforcement, it's one, illegal, and two, probably not very good for communities. So that's pretty much all I have to say about that.
Okay, hi everyone. everyone. First of all, I apologize for joining you partway through this panel. I really want to thank Carrie and you all for having me here. It's really an honor.
We're sharing an audience tonight. There's another immigration panel a couple buildings over.
Yep.
So there are 2 immigration events coming.
Great. Okay. Well, I'm really thrilled to be here. And I want to, before I go into my talk, which is going to be about criminalization under the 1996 immigration laws, and to provide a little bit of kind of historical context to the issues we've been talking about today, I wanted to say a little bit about what a law school clinic is. So my primary position at UC Irvine, the law school, which is a new law school, by the way, and hopefully I can convince some of you to apply to law school there, is I run an immigrants' rights clinic. And a clinic is an intensive course where law students get to, under supervision of course, work on real cases, handle real cases, stand up in court and argue real cases to represent clients on a pro bono basis while they're in law school. And the idea is that's part of your practical training in order to become lawyers, that people learn best by doing. And so after you've sat through some of your classes where you learn what the law is, you get to apply it to a real case representing a real client. And in the Immigrants' Rights Clinic, we primarily represent individuals who are facing deportation, either detained in a detention center in Adelanto, in San Bernardino County, or in Orange County, or we represent undocumented immigrant workers who are exploited in the workplace and trying to assert their labor rights. So that's a little bit about our clinic, and some of my remarks today are going to come out of cases that we've actually handled in the clinic. So if you have any questions about what a law clinic does after the presentation, I'm happy to talk about that. Under the 1996 immigration laws, as we've heard today already, by the time Congress was considering immigration reform in 1996, there had already been build-up to that moment, and a lot of rhetoric. It was a time in America when there was a lot of talk about crime and the harms associated with crime, and there was a kind of fear of crime and a fear of the consequences of drugs and crime associated with drugs. That rhetoric kind of peaked in the 1990s and catalyzed some shifts, major shifts in criminal justice policy that gave rise to what we know today as the mass incarceration system. At that same time, there was rhetoric that conflated the threats from crime in American society with immigrants. And so there was a construction of an immigrant, oftentimes in people's minds as a black or brown immigrant, that helped people associate immigrant with crime or criminal threats. And that it paved the way to a number of reforms, ultimately harmful reforms at the federal level, including the 1996 immigration laws, but it really started in the 80s, that form a lot of what we know as immigration law today. I'm going to talk specifically about 5 trends that I believe that grew out of the 1996 specifically. There's 2 laws in 1996 dealing with immigration that I believe have led to our what we understand today as criminalization of immigration. And the 2 laws in 1996, one we've already heard about, which was enacted by Congress in September of 1996, called the Illegal Immigration Reform and Immigrant Responsibility Act, or IRA. Earlier that year, in April of 1996, there was another law, and it was called the Anti-Terrorism and Effective Death Penalty Act. A lot of that law was geared towards reforms in other aspects of the law, like criminal justice law and, as the name says, certain anti-terrorism policies, but major portions of the law also dealt with immigration. So these 2 1996 laws, what did they do? So here are the 5 trends I see leading to criminalization. The first is that these 2 laws together stripped immigration judges, they are kind of administrative judges, of the ability to consider individual equities in immigration cases and made criminal history the primary consideration under immigration law of who is allowed to stay in this country and who must leave, and especially people who are already living in the United States. And so criminal history becomes the primary sorting mechanism in immigration law of who can stay and who must go. And it treats individuals with criminal history as beyond redemption. That's what the primary thing that the 1996 immigration laws do. It expanded the grounds for deportation to include minor criminal offenses, and it made vulnerable individuals who were never vulnerable or as vulnerable to deportation before under immigration law, including lawful permanent residents and a lot of individuals that you might not think of as being vulnerable to deportation, like veterans, people who have served in our military. It made them vulnerable to deportation for really minor criminal offenses that they might commit after they come back from their service and are trying to integrate back into our communities and may fall into homelessness or substance abuse, etc. And this expansion, this vast expansion of the grounds of deportation included an expansion of a definition of something called an aggravated felony under federal immigration law, which actually doesn't require that the offense be a felony. The definition of aggravated felony under federal law actually includes a lot of offenses that are considered misdemeanors under state law, and it expanded this list of aggravated felonies from 3 to 28 offenses in 1996, including minor drug possession. So that is now on the list of deportable offenses. It's not an aggravated felony, but it is something that can render a lawful permanent resident who's lived here their entire lives vulnerable to deportation. It also, the 1996 laws created many criminal bars to relief. So prior to 1996, if you did commit a criminal offense, let's say it was, you've lived here generally free of contact with law enforcement, but had a single offense, before 1996, you could ask the immigration judge for a second chance. And so after 1996, that second chance is no longer available because if you have any criminal history, you're barred from applying for many forms of relief from deportation. In many cases, the 1996 laws applied retroactively. So you'll learn if you end up learning about criminal law, you'll learn about something called non-retro. If the law changes, it can't be applied to punish people going back in time. People have to have some notice of what the consequences are of their conduct. In immigration law, there's not that requirement. And so 1996 laws generally applied retroactively, although there are some exceptions. And if you get a criminal conviction expunged so that it's no longer considered a conviction under state law, that still can subject you to deportation under federal immigration law. So even if you get expungement or other forms of rehabilitation, rehabilitative relief that is designed to kind of ameliorate the collateral consequences of a conviction and allow you to move on with your life, that does not apply in immigration law after 1996. Those individuals still face the consequences of their convictions. Okay, that's the first concept, the first trend in criminalization. The second trend in criminalization is that, and we've talked a little bit about this, Salvador in particular, is that the 1996 laws created new legal mechanisms for criminal justice system apparatus to be co-opted for immigration enforcement. And so that 287G agreement that Salvador talked about, that was enacted into law as part of the 1996 immigration laws. And the first 287G agreement didn't really kind of come into effect until after 2001. Who knows what happened in 2001 in our country? Yes, and so that led to the first 287G agreements being signed, but the provision existed in immigration law in 1996. And then, as we've heard, there have been other efforts to kind of utilize and bring criminal justice system bureaucracy into as a mechanism for immigration enforcement, like the Secure Communities Program, immigration detainers or holds, and the use of administrative warrants to put into law enforcement databases. All of these, as Salvador explained, are not the same as a warrant in the criminal system that would be given a probable cause stamp of approval by a judge. These are administrative warrants that do not give law enforcement authority to hold somebody and deprive them of their liberty, but oftentimes local police are confused when they see a warrant or a hold, and it's administrative. They believe it has the same legal effect as something in the criminal system. And so that has really entangled our local police and criminal justice system in the kind of immigration enforcement mission. And we've talked already about the policy implications of that, so I won't go into it. The third trend in criminalization is the asymmetrical migration of criminal justice strategies into the immigration system. And so and I'll talk about why I say asymmetrical. So one significant shift or trend that we are seeing in the immigration system is the increasing use of detention to hold individuals who are facing or fighting their deportation cases. They're held in essentially jails and prisons that look like the same jails and prisons that we consider punishment in the criminal justice system. And many people, including people with minor drug convictions, are now held without the possibility of release on any sort of bond in the immigration detention system, where they would be eligible to argue to a judge in the local criminal justice system if they're picked up on that drug offense. Hey, I have family ties here, I'm gonna come back to court. If you release me on $500 bail, I will come back, I'll post that bail and I'll come back to court. There's no possibility of that now as a result of the 1996 immigration laws for many immigrants who are trying to fight their deportation cases. As a result of that, many people, and there's also no right to an attorney in the immigration system, many people just give up the fight and accept deportation, even though they might have a chance to stay in this country had they obtained a lawyer and been willing to fight their cases and stick it out. In addition, strategies such as law enforcement raids, the use of kind of high-profile raids and SWAT teams, as well as the expansion and the militarization of the Border Patrol. So from the early 90s to 2013, you see a tenfold increase in the budget of the United States Border Patrol. These are other types of strategies that we have often seen in the criminal justice system that are now being migrated over to the immigration enforcement system. Now, why did I say asymmetrical? Now, to the extent you guys know something about the criminal justice system, if you're arrested in the criminal justice system, what rights do you have?
To an attorney.
One is you have a right to an attorney, and I just explained there's no right to an attorney in the immigration system, right? If you can't afford an attorney, you have a right to an attorney. Bail, so I already talked about, in the criminal justice system, if you're arrested and you haven't yet been found guilty, you have a right to ask for release and an ability, a chance to come back to court on your own. What else? What other rights do you have in the criminal justice system if you're arrested?
Right to remain silent.
A right to
Remain silent.
A right to remain silent. That actually doesn't exist in the immigration system because it's considered civil, so you don't have a right against self-incrimination in the immigration system. What else?
Theoretically, a speedy trial.
Speedy trial. There's some cases take some time. So in the criminal justice system, there's at least a timeline for when cases have to be complete. In the immigration system, let's say you're detained. We've had clients who've been detained for 2.5 years trying to fight their immigration cases. So there's no, limit on how long an immigration case can take. What else?
Unlawful servitude.
Okay, so right, the rules against when somebody can be arrested and on what basis are a little bit different in the immigration system as well. So the point is this, you have criminal justice strategies being employed. For an individual sitting in a detention system, it sure feels like punishment. In many instances, it feels like being punished again because they've already served their time and oftentimes have already started to rehabilitate and rebuild their lives. But they don't have any of the rights associated with being in the criminal justice system because legally there's this fiction that it's considered civil. Okay, so that's the third. The fourth trend in criminalization is that one of the consequences of criminalization is ultimately what I think we've seen in a lot of our clients' cases is a process of dehumanization. And so in many cases, the 1996 laws actually went further than in the criminal justice system and stripped people of due process, what we might consider due process at all. And so one big reform was that for asylum seekers, now they're subject to something called expedited removal, where they don't even get to see an immigration judge. They have to make their whole case to a Border Patrol officer and then a USCIS immigration officer. And if they don't pass those screenings, they're deported before ever seeing an immigration judge. There are other summary procedures, summary deportation procedures, where somebody doesn't get the full process that they may have had before 1996. And today, the consequences, about 2/3, about 70% of deportations are what we call summary deportations, where somebody doesn't even see an immigration judge. And this includes most refugees that are coming to the United States, as well as many people who come in contact with government officials in the interior of the country and who have lived here for many years. And then the final way in which I think the 1996 laws have led to criminalization is something that the 1996 laws did not do. And so as Salvador was talking about immigration reform and a pathway to legalization, the 1996 laws did not create that possibility. The last time we've had major legalization in this country is 1986. And so as a result of that, the undocumented population in the United States has grown significantly from about 3 million in the 80s to 11, 12 million, right? And that, the idea that we have millions of people here who are undocumented, especially in a kind of second-class status, created opportunities for the criminalization of the act of migration itself, and for that to affect many people. So at the federal level, there's been a shift and an exponential increase in the number of cases prosecuted in the federal system for essentially what is entry into the United States or illegal re-entry into the United States. That's a crime of migration. And then at the state level, in places like Arizona, where our clinic is litigating a case against Sheriff Arpaio. Actually, one of our law students argued in court a couple of weeks ago to try to stop his worksite raids. The state level, there has been a creation of essentially new crimes that problematize the survival behaviors of undocumented immigrants, like attempts to seek work or attempts to drive. Those are the use of local criminal justice laws to criminalize immigrants for survival behavior. And so that has been on the rise, although we've seen a recent, hopefully a recent wane of that. And so that's the fifth trend, and I think the sum of all of these trends has significantly increased the stakes of any contact with government officials or law enforcement at the local, state, and federal level. And also really kind of builds on some of the racial disparity in the criminal justice system, and then kind of uses that as a starting place for our policies around deportation. Thank you.
So we started by having Professor Chang break down the different branches and how they, or how more or less they're involved in immigration. And as he said, what we wanted to focus on was more or less what the effects of the upcoming election can have on immigration. And something I want to ask the panel is, I can think of two positions, AG and the open seat that was left with Justice Scalia in the Supreme Court, what their thoughts are on how this election ties into those two positions, and if, I don't know, Professor Chang, you can elaborate a little bit on the importance of the Attorney General position within immigration.
Okay. Well, so there was, because of the restructure in 2001, what used to be, and this is why we need comprehensive immigration reform, because even currently, the Immigration Nationality Act still calls the Attorney General as the one who's being responsible for everything, even though now it's the Secretary of Department of Homeland Security. The AG still does the appeals, which is the EOIR, so the Executive Office of Immigration Review, and then the Board of Immigration Appeals. So that's what's under the purview of the AG. But Department of Homeland Security is now what's responsible for the administration of immigration, so USCIS, ICE, and Customs and Border Patrol. Now, the president has the ability basically to task ICE with, like basically increasing deportations, or as we talked about in my little section, with offering prosecutorial discretion to deprioritize certain folks. So that's where the administration of immigration actually gives the president a lot of power. In terms of the judiciary, I see it as less important, largely because the judiciary is so uninvolved in terms of just saying, well, if Congress has spoken, we're going to say that Congress has a lot of leeway through plenary power. And under the Chevron doctrine, the executive agency interpretation of the law we're going to defer to them. So that's where I see the judicial appointment being less important, I guess, in some ways, when it comes down to the effects on immigration itself.
Okay. So you want to chime in on their thoughts?
No, I would just say, like the AG, I mean, it's interesting, over the last bunch of years, we've done a lot of immigration advocacy around DHS, very little around the AG and the Justice Department. And the fact is that, I mean, DHS is the massive machinery that's kind of leading the deportation charge. It's like, literally, they're the ones that set up, like literally somebody in 2008 put on a whiteboard, 400,000. And that's the quota per year. But DOJ is really responsible for like the massive numbers of reentry charges. There's more like there's more federal reentry charges than any other federal conviction today. In terms of like literally criminalizing, not like abstractly, philosophically criminalizing, I mean literally turning people into felons with immigration reentry convictions, more so than any federal conviction. I mean, it's insane. The numbers are just ridiculous. And that's DOJ, and nobody. I mean, that's not even part of the conversation, when we talk about immigration. That's the only thing I would say about the AG.
I will add one thing. So I'm a person who actually started immigration practice when it was still INS, Immigration Naturalization Services, and back when I started practice before 9/11, it was much more of a collaborative process between the immigration attorney and the government. That we were trying to figure out, okay, so we have this person with status problems, let's figure out a solution for them. After restructuring Department of Homeland Security and ICE, it became much more adversarial. So ICE was more concerned with, well, this person has done something wrong, let's kick them out. And so it's much more adversarial now. And that's, I think, just a culture that I do think that Obama inherited the restructuring culture of the Bush administration, in that DHS is now much more anti-immigrant and more about security rather than let's figure out solutions for citizenship and immigration.
I know many of you discussed DACA and the whole process, that it doesn't mean you have a legal status here in this country now, but it's that you're kind of like placed lower on the list as far as when it comes to removal. In that sense, I mean, if we were to get a president or, that removes DACA, we now have potentially, I don't know how many millions of individuals that have signed up for DACA are now, have, for lack of better terms, come out of the hiding and said, here I am, this is my address, this is my phone number, this is who I am. Once that protection, if that protection were to be lifted, what do you think are the potential consequences? Do you feel that they will remain at the lower level, or would they just become kind of open game and be pulled because, I mean, they're kind of like out there now?
I mean, I'm sure other people have more to say about this, but what I will say is that before DACA, there was a time when the administration, this was still under the Obama administration, Dreamers were in fact being arrested, detained, and in some cases deported. And so, in our very recent past, Dreamers were vulnerable. The reason why we ended up with DACA is that in 2010, when Congress failed to pass the DREAM Act, Dreamers started to organize themselves. I mean, they were organizing far before this, but because of their political power, they were able to pressure our government to put DACA into place. And so I think that since that movement is still there, I would be surprised if we could easily go back tomorrow, even with a different president, with different policies and priorities, that there's a foundation now there for that. And I think there would be some backlash if that policy were yanked away overnight.
Yeah.
So then you don't think that there would be some sort of collaboration? I mean, she was talking about sanctioned communities earlier, and if you do in fact end up with Donald Trump as president, that does become a huge problem for a lot of folks.
Well,
Take that?
Answering over the surface, and it's just very informational, but you're not really answering the question.
well, so let me address what you're talking about in terms of the sanctuary city. So there has actually always been, and this is part of what Professor Lai is saying in terms of we've prioritized like law enforcement. The existence of the U visa and the T visa, particularly the U visa, which is the Victims of Crimes visa, which proposes that you are able to get legal status if you cooperate with the
But
prosecution.
that's very different than deferred action. His question is addressing DACA.
Yes. Okay. Well, so okay. So what is your question? Specific question
But
then?
you're not answering his question.
Well,
What's gonna
my-
happen to
okay,
people?
well, my
What
question-
do you predict, since you're within the law, you
Hold-
practice and you're
Hold
a
on.
professor?
I'll repeat my question. My question simply was, given, I guess, if we get a president that doesn't support DACA, right, that wants to go ahead and yank it out, cancel it, or whatever, what do we see happening with the many individuals that have signed up for DACA and have been under its protection for the last 4 years, I believe? Essentially, and I believe her response was that she believes that there is a trend that has been set. I mean, the law and politics works in such a way where if there is a trend set, and feel free to disagree, politicians are gonna be less likely to go against that grain because they've seen that it's been settled, right? We have many people in this country today aren't arguing against DACA, they're not arguing to pull DACA. And politicians, in my opinion, would be removing individuals, even if DACA gets yanked, would be at the bottom of their to-do list, given how society has accepted it.
I guess the question that I will ask around all of that, and I think the fear in the immigrant community, and I grew up in New Mexico, most of my friends when I was little were undocumented, the fear of my friends is that Donald Trump has created such an atmosphere that people feel that if he were elected, that it is almost like it's open season, like it's hunting season. And it's immigrants who have the targets on them. Because that's just the vitriol that has surrounded this campaign. So I think the real question is that actually the case? I think you guys are suggesting it's not the case that immigrants will become, open hunting season. But at the same time, if we do move to the alt-right, and we have an alt-right justice that's gonna say, get them out of here, is that a possibility? I think that's more of the question.
I think I can try to address that question and also clarify. I'm not saying that, if one of the candidates becomes president, that there will not be harm. There will absolutely be, if what he has said, he tries to implement, there will be harm, and families, even though they're being torn apart today, will be torn apart in ways that we are not seeing today. What I will say is the way that bureaucratic institutions work, and institutions have interests, an institution even like Department of Homeland Security and USCIS, which administers primarily the DACA program, if in implementing DACA, what they've done is gather a lot of people's information on the promise that you're now applying for something like deferred action, you can renew. If that ends up becoming an immigration enforcement tool, that will have severe consequences for that agency's ability to administer programs in the future. And so there will be a lot of people within USCIS and government who are currently running our government who would have objections to doing that. And that's why when I talk about momentum of the law and being able to just flip the switch overnight, I think there can be somebody at the top who may desire that, but the way that's implemented is very hard to do.
Go ahead.
Sort of to bring both those questions together, and then maybe to ask Salvador, in light of your separation of powers, I would say that one of the difficulties in having an incomplete court, right, is that, and having a dysfunctional Congress, to bring those two things together, is that we're doing a lot more by executive action. And so a new president brings new possibilities for executive action in whatever direction that's going to go in, maybe more, and the precedent possibly has been set with some of these actions that we might favor and we might like, but it could go in a different direction. But it does seem like eventually we're going to need a ruling from the court to tell us what the limit of the executive action is going to be. We don't have a precedent for that. It's always just been a matter of customary law that has carried forward about how far, what it is that presidents are capable of doing, or the executive is capable. We don't have a clear ruling on it. And so I don't even know if that's within the purview of the court. I don't know that it's ever really been raised, whether it's a political question that the court would not touch, if there's a limit to executive action. But if the Congress continues to be dysfunctional, and the only way we can get this kind of work done is by executive action, I just wonder if there's a limit that anyone foresees that the court could put on.
Well, in terms of the president, the executive office cannot actually create eligibility for permanent residence. So that's all up to Congress. President also cannot, even though Trump would like to, just say that, okay, determine the rules for admissibility either. So that would require Congress. Now, theoretically, Trump's position that we're going to ban all Muslims, that theoretically is a power that Congress could do, but I don't think we'd ever have enough votes to do that in Congress, no matter what. Now, what could happen, though, is certain types of executive actions, such as those that occurred during World War II, such as those that occurred immediately after 9/11, that severely restrict immigrants. But you could not actually have an executive that could create those types of changes in the law. It would require Congress.
Yeah, I think I think the DACA question and that question specifically, in terms of immigration law, goes to the heart of a lot of the stuff we're dealing with. when we were working for the president to take administrative action, like we used to say DACA for all. Internally, we always knew that we would bump up against the political limits of the executive way before we'll ever reach the legal limits, right? If we know that there's an 11 million population of undocumented folks in the US, Obama could have prevented the deportation, say, of like 8 million, right? He can't stop all 11 million deportations because it's based, that authority to provide discretion is discretion to prioritize some versus others. So he can't say no deportations. I mean, we could make some, I'm sure we could find some legal arguments to say that, but generally the legal consensus that, yeah, like that legal is much more expansive, but it's much more expansive, but the court's not even getting to that point, and we're gonna hit the political reality or the institutional capacity issues way before we hit the legal issues. I think in terms of DACA, first of all, if Trump wins, my first gut reaction is like, all bets are off. We don't know what the F is gonna happen, right? Like I mean, to be clear, he's an entertainer and a fascist, and if he wins, like all bets are off. It's like Brexit. How does Brexit actually happen? Who the heck knows, right? We won't know until it's actually happening. Like my butt would hope that like the camps have Wi-Fi if Trump wins. Putting that aside though, like the fact is that even for Trump, DACA has not been the target. Sanctuary cities have been the targets. Immigrant workers, specifically Mexicans or Central Americans.
But he has publicly said that he would revoke any executive action that was taken by President Barack Obama.
Yeah.
He
Sure.
has made that, and he stated that in multiple speeches. Sorry to cut you off. Continue.
No, totally, yeah. So, like what I'm saying, like he's also said that he's going to ban all Muslims, but at some point, some of those would be blocked by the courts. What I'm saying is like he would try to do them anyways. I think my answer is like all bets are off in the sense that who the F knows if he would actually try to do it? Like even when you talk to his own policy people and the folks in his party, like nobody thinks that would actually happen, right? Like most folks think that it's just a talking point. Maybe he would try to do it. Honestly, like I don't think anybody, including his campaign manager, know what the answer to that question is, DACA. What I think is real is that what is being attacked, not January 20th in inauguration, but what is being attacked right now in the times of Trump and what the situation we're in, sanctuary policies right now are being attacked. Like low-wage workers right now are being, like basic fundamental rights that we just assume we have, like protections against unlawful search and seizure and unlawful detention. I'm sorry?
Yeah, I know.
Anyways, but like I think what's the point that I was going to make, and I think this is important specifically for the folks in the room. Like President Obama didn't deport more than 3 million. The DHS deported as many people as they could, given the institutional realities, right? They would have probably deported more if institutionally they could. Could a Trump presidency deport a little more? Probably. Who knows? So my job is to do a lot of like, and previously it was like the Not One More campaign, Not One More deportation. Right now it's a lot of like the ICE Out campaigns. And so my butt is like jumping around from city to city doing like ICE Out of North Carolina, ICE Out of Dallas, ICE Out of Houston, all this stuff. And what ends up happening, the numbers of deportations haven't been moved mostly because of prosecutorial discretion. We went down from 400,000 to closer to 200,000 specifically because of sanctuary policies. Because of trust, we call them trust jurisdictions, like the California Trust Act that said that California would severely limit which ICE holds it complies with. And this isn't me saying this, that's Secretary Jay Johnson basically acknowledged.
So let me cut you off there because I know we're running out of time. I kind of want to like go a little bit deeper into what you're bringing up now. Because Professor Trefethen, you mentioned sanctuary cities a lot. It's been discussed a lot tonight. So it got me thinking about the idea, okay, what about a sanctuary state? California has recently passed a bill where, and going along with what Salvador is saying, prosecutorial discretion is where a prosecutor may consider immigration consequences in filing of misdemeanor or felony complaint. So meaning that if you get arrested for let's say a domestic violence charge, which usually will kick you out of will bar you from any relief in the immigration court, a prosecutor could use his discretion and say, well, given his legal status, maybe I won't do a domestic violence charge, but maybe I'll do a simple battery, which is not domestic violence. I don't believe it's an aggravated felony either.
Well,
So therefore,
Well,
there's
if
a-
the sentence is less than 1 year.
and now it's in California, they also passed that law where misdemeanor sentences can only be 364 days instead of 365 days. So technically, it's not a year. So
Well, there is so there is this other thing called a categorical approach, where they can use, even if it's just a simple battery charge that they plead to, they can use parts of the record to prove that it was a domestic violence offense and still make them removable.
okay, so let's go with well, you can help me out. What's the charge that would be non-deportable as from a
For domestic violence, that's
assault?
I think if you do. This is
Don't
like
try.
a law school.
Pretty,
Right.
You
disputed.
have a simple battery,
Let 'em
but
go.
there's nothing in the record.
Yeah, okay.
You
Well,
have
the
to
idea
rinse-
being,
scrub
right,
everything clean, basically.
the idea being that a prosecutor can change the charge or choose to charge something else in order to maybe protect this person's immigration status. That's something that was passed in the California legislative and it's implemented now. In addition, we mentioned U visas. U visas is something where it's up to the prosecutorial agency to determine whether they're even going to accept a U visa application and consider it. California passed a law requiring all prosecutorial agencies and law enforcement to consider U visas and respond to them. Now, with this idea, it kind of feels like California as a whole, we're moving away from a sanctuary city to maybe a sanctuary state. So, I guess my overall question to the panel is, we talk a lot about the presidency in the upcoming election, but are we ignoring the power of local elections, of your governor, your assembly members, your state senators, and their power as far as immigration law?
And there's a couple others. Just last year, California enacted a law that provides for essentially an ability to, before if you pled guilty but then agreed to enter a drug treatment program, that would still lead to deportation. Now there's a mechanism by which you can go back and withdraw your plea if you successfully completed drug rehabilitation, and that can avoid the deportation consequence. So there's a number of ways in the past few years that California has made reforms to its own laws, and I would argue these are lawful attempts by California to protect its own residents for good policy reasons that will help to reduce the harm from flowing from federal immigration laws. So there are definitely things that states can do, lawful things that states can do, and it's not, it's not pointless to kind of do that advocacy at the state and local level.
I think that for those who argue that sanctuary cities are a real concept, and those who fit into that type of thinking, they actually categorize California as a sanctuary state along with maybe 3 other states. I think Vermont, Rhode Island, and Connecticut have enacted measures that are sort of protective in this way, or at least dedicated toward other alternatives than helping out with ICE. I have somebody in the back.
No,
Go ahead.
I just have a more general question, I guess. Given like the whole situation with Congress, the criminal laws that affect immigration laws, what can we do, I guess? Maybe like, more activism or, advocacy, to change like the way we view the immigration system, given already that I feel public opinion or like approval of how we deal with immigration is kind of set already, given that there's like a whole criminalization image to us, like I don't feel like our image, the image of immigrants stuff that it's already, like he says, it's already we're felons or we're friends kind of thing, like there's no, like with the Jose case, it's like putting a face to it, right? Like we're human beings or we're parents or we're kids or, so my question, like what can we do, I guess?
Yeah, I think like whatever momentum in terms of the question, like the question that you're making, whatever momentum we've made, whatever progress we've made in the last couple of years has not come out of DC, has not come out of either of the parties, or like the experts out of DC, and honestly, it hasn't come out of like the big, well-funded firms or organizations. Like literally, it's been a lot of local groups that have created the space to talk about these issues. And that's why it's so important. Like I think the question that you're asking is like right on, because it really has been the local folks and students and community members that have really made all the momentum. So like I feel like I would talk about like a battle of the trenches. I don't even remember if you remember World War I, where it's like we move a couple inches here, a couple inches here, a couple inches, and we all move forward together. It's similar like that in terms of the standards around like what we call like the trust policies or trust jurisdictions, or interchangeably like the sanctuary jurisdictions. A couple years ago when the Trust Act was passed in California, it was like no ICE holds, but only for low-level offenses, right? Like that's all we can get past in a lot of jurisdictions. As the years went by, we started getting a little bit like, no, we shouldn't make exceptions. Like if it's unconstitutional, it's unconstitutional to hold people without, probable cause. And so then we started passing trust policies, sanctuary policies, whatever. No exceptions. We will not abide by any ICE holds, right? Then some jurisdictions, some cities said like, well, it's not just ICE holds. Like ICE has a whole series of tentacles it uses to get a hold of people. And we could block those too. And like New Orleans has a policy which limits information sharing, and that's lawful, Like there's a whole bunch of, and again, it's like trenches, like, it's like moving the standard forward. And all of that to say that campuses in particular have in large part been outside of that conversation. And so when Jose Alvarez gets deported after being transferred because of a campus police department, like that's outrageous that campuses across the state are not passing more robust sanctuary policies or trust policies or ICE out policies, whatever we want to call them. And so, for example, when the campus, when some, like they say here on police, like, don't worry, the police will not ask for your immigration status. That's an important step, but they also shouldn't be information, there should be limits to the information they share with ICE. They shouldn't be allowed on campus. Like there's a whole, they should have a written policy, no ICE holds, no ICE notifications, And so that's something really specifically that when we're fighting this guerra de trincheras, this war of trenches, if a campus comes out and puts out a really strong policy and says, you know what, felons are also families, like whatever protections we have on this campus is for everybody, not just the students, the workers, and it's not just ICE holds, it's access on campus, That would have a huge impact on other campuses. It would create a model for other campuses. And honestly, it would help a lot of cities trying to defend their local, community policing policies. And basically, I'm like pitching, like this is something that campuses should be doing already. And just like to give props, because there's a bunch of folks in the room that have actually been working on the Jose case much longer than I have, like the folks in the back and a couple of professors and academic types. But yeah, totally like props, because that's honestly, in the long term, like the progress and momentum that we've made on immigration relief for anybody hasn't come out of DC. Like honestly, it's come out of like the activism, basically folks like responding to really concrete cases like Jose's case.
I know we're running out of time, but I just want to ask a question really quick. And I have a friend who fled because a cartel literally came into his school and was picking out boys to use as runners. And so they came in, told him he was coming back the next day. They were taking his runners. He lived up in the mountains in Chihuahua. And so his mom packed what they needed, and they fled their house in the middle of the night. These children know you're going to be dead by the time you're 13. And that's why they're here. But you can't use that. You can't apply for asylum because there's a cartel who's literally, sorry kid, you're 10, you're 11, you're coming with us. You can't use that. You can't use the fact that you live in a house that has a dirt floor, no clean water in your village, you're here, if you can apply for asylum if you're Cuban, but if you're Guatemalan and your village is literally overrun with violence and or just extreme poverty, you can't use it. Are the changes that we really need to make to immigration the, I guess, qualifications under which we take people in? Do we need, I guess, should we? Like, should that be the thing that we focus on? That you can apply for asylum based on economic situations, based on violent situations? Because it seems like that would pretty much create millions of new people that could apply for asylum, that could have a path to citizenship, that wouldn't have to move into this underground economy. I mean, it seems like that's a thing that we just don't talk about. We're like, well, everyone's poor, we can't fix it all.
Want to take that? Considering
I
reforming our asylum laws?
Huh? So I teach an immigration class. So part of the question of like who gets to apply for what is really dependent upon like the U.S. intervention policy around the world over the last 40 years. So for instance, why Nicaraguans can apply for TPS, temporary protected status, is because we were fighting a communist regime there. So a lot of this is actually holdover from the Cold War. Same thing with Southeast Asians and Vietnam, but not for instance Cambodians. And a lot of people actually don't know, we were covering this in class the other day, that you can actually be naturalized as a U.S. citizen if you're Cambodian and still be deported if you have these like low-level felonies or certain felonies. My co-instructor, she was talking about that. There's some actual videos about that. So in terms of the policy, like there's all kinds of things that we can fight for, but because of the craziness of that, it's really difficult. And that's what relegates everyone to fighting sort of in the trenches. And because those fights are going on in the trenches, like, I think I'm going to try to address the question about, the bureaucracy, is that there's good people there. Like, there's good people, like, even though we want to assume that, like, immigration is terrible, and INS, formerly INS now, UCSIS, there's people there who, like, would slow whatever Trump wants to do to, like, a crawl, to make it sure that it doesn't happen the way that he wants it to happen. And so, it's really about our intervention policies. And the reason Cubans can come is because, Cuba is a communist country. So it has to do with, I think, the way that we respond. And we actually do need to lobby our representatives in terms of what we think policies are. I think the point that was made earlier about what can we do, it's really important, I think, that we have a conversation, we expand a conversation about who's deserving. Everybody's deserving. Right? I think there's a lot of debate within the undocumented community about dreamers versus, some people aren't students. Some people didn't go to high school. They came here to work. And how are they deserving and not others? So I think this space is really good. And we need to continue those conversations and actually push for legalization. One of the things that I try to talk to students about or people about is like actually having, thinking about citizenship on a local level. So technically you can get cities to pass local laws where, undocumented, like national folks can vote in the city elections. You can do that. There's nothing stopping folks from doing that. You actually have more access to local government and it affects you more in your daily life than sort of national politics do. And so part of that is how do you do that? You have to build movements, locally. You have to organize on this campus to get the president to think about, okay, not just, not felon, I think that was the holdup, right? Is that, we don't want to protect felons. Well, why not? They're people too. They serve their time, they're not in prison.
Well, in this campus, you're allowed to pull a knife on a black girl in class and you still get to stay here. So, not sure our president's doing anything on that.
Yeah.
Wasn't there a question, last question?
No, I just had a comment in terms of just how you can get involved, especially with the issue of immigration. That we need to be national federal government. But as someone was saying, it doesn't have to be a lot with the local ordinance. We wouldn't be where we're at if it weren't for documented visa families coming out 10 years ago. To the point where we have 2 city council members going to write an op-ed against why deportations are bad.
that didn't happen, you know, from back in the day. That happened because local groups and local people came together and things to be done. And it's actually even an opportunity to do that. You know, the folks who are organizing our local settlement case will be at City Council next Tuesday, asking for a resolution in support of this case, and to have Long Beach City Council say that we support our undocumented immigrant community, not just, you know, these deserving Dreamer students, but their families as well. And that's a big deal because even though resolutions are, it's a word, it's not binding, it's something that we're willing to, for years to come, like, hey, 2-3 years ago you said this, why are you acting like this now?
One last question or comment?
I was wondering, because I come from a criminal justice background, and then I know, like, when it comes to mass incarceration, a lot of times the conversation is about the cost. And then, I forgot your name, the grace word, but you mentioned that it was 3 million deportations in, I think, 8 years. So I was just wondering if any of you know, like, what the cost is, because that could possibly be something to have people reconsider in terms when they take the cost in consideration, like, okay, you're spending all this money to deport people. That's also a problem too.
The cost, I don't have exact numbers, but I did look up because the budget of the Border Patrol has increased tenfold. It's now something like 3.5 billion. ICE is something similar to that. Our immigration detention system also costs our federal government billions per year. And so when you add those up, you can see what the cost is, and you think about what if that money was being spent somewhere else, right, to enrich our own communities.
And just to add to that, like, an article came out not too long ago saying, like, that the place to target now for detention are immigrant communities. That is where they're thinking of things, the GEO groups, CCA, like, that is where they're making their mind. They realize that this is a profitable business to incarcerate immigrants.
Okay, one last comment.
That
Now,
was the other thing that we're talking about. I've been involved with people for Palestinian and Israeli justice, and we were talking about boycotting, and one of the things that we were working is G4S. And G4S is a corporation that imprisons people, not only in Palestine and these Palestinians, but also here in the United States. And who do they incarcerate? The undocumented here. They make money in all these different countries, criminalizing, incarcerating innocent people. And anyway, yeah, G4S is another corporation.
G4S?
Yeah, G4S. Yeah.
Is that a
It's
private prison?
It's a private prison corporation, yes, yes.
I'll leave the last comments to our panel. Anything from?
No, just a shout out to the folks from, basically there's folks here that, like, from the Long Beach Immigrant Rights Coalition and from ICO, it's a PICO affiliate, that really, like, and along with, like, a bunch of students here on campus are really the ones that blew up Jose's case. And it's so important because when we think about, like, what we can do, like, I agree there's probably so many things that need to be changed in the law and that Congress could do, but it's not looking great. And even if there is a bill, the more progress we make locally or at the state level, that completely changes the conversation in Washington, D.C. It's incredible. When California passed the Trust Act in 2013, it more so than millions of dollars that were spent lobbying in D.C., when California passed the Trust Act, that changed the entire conversation in D.C. Like, it was like a bomb. That honestly, like, moved the conversation forward in terms of what we were talking about. And I think right now, for example, what the compañera was mentioning is that the city of Long Beach is going to be looking at a policy in response to what happened to Jose Alvarez. So that's incredibly important, and that is going to be news, and that goes a long way when we start talking about, like, challenging the good immigrant versus the bad immigrant, you know, who's deserving, who's undeserving. When we say, like, yeah, Jose Alvarez, he does have he has a felony conviction, actually, and you know what, he's still deserving to be here, right? Because he's been here for a long time, because he has kids, because he did his time for so many reasons. And so in terms of what we can do, that, you know, we'll all be here after this event if anybody wants to chat. But next Tuesday at the City Council, that's like a big that can be like a really good start.
I want to thank the panels for taking the time.